Come on, Soda Pop, let's go.
Hi, Greg Neitzer, Sioux Falls. I just want to preface this by saying that I've only started looking at this for about a week, and I want to talk about Article 6, specifically initiative and referendum, and I can come back in a few months with some more solidified ideas. So in 2014, we had an unprecedented amount of activity in that regard. We had 2 initiatives and 2 referendums. And when we think about what the function of those are, it provides a way for citizens to bypass their representatives and address a grievance. It's a safety valve in our form of government, empowering citizens who have grievances. And as such, the elected body, as well as the government that body represents, has a conflict of interest and a vested stake in the outcome of those petitions. In late 2013, I formed a ballot question committee named Forward Zoning. We advocated for the adoption of shaped places. We actually, in that regard, so we advocated the city's position, not officially because we were an independent body, but it just so happened we were advocating for shaped places. So as a group of private citizens, we were free to advocate all we want, and we tried to do that and tried to educate the citizens. The city, however, is barred from advocating. Because of that prohibition, the city, in my opinion, should have stayed completely out of the issue, and that includes the educational presentations that they had. Whether or not it was education or advocation is something that's a serious debate. I personally attended most of those. I think the city employees did an incredible job in trying to do their best to stay objective and try to put it forward as best they could. But I think they were in a really bad position because they're not supposed to advocate. And when you take something even like the zoning ordinance, it's so large, it gets very difficult to not be perceived as advocating. For example, they might say, well, the new ordinance requires a buffer yard, while the old one does not. That's completely factual, but it could be construed as being advocation. So it was very, very difficult, I think, for them. So I think it's virtually impossible for the city to be objective, no matter how hard they try, because we're all human beings. That conflict of interest creates a clear and present danger that the information presented, and just as important, the information that's left out could be slanted or it could be subjective. Citizens, including myself, I think were perfectly able to advocate. And then in addition to that, there was the city attorney's explanation. And once again, I think they probably did their best, but I have the city attorney's explanation here, and they're quite lengthy. And they run into the same problem where there was, when you look at what's in and what's out, you can read certain things, for example, with the shaped places, where it talks about shaped places does this and the old one didn't do that. Once again, it gets really dancing very close. And I think once again, when you have the city brought forward shaped places and they adopted it, it's very hard to think that they didn't have a little bit of something going on in their minds where they were, maybe selectively editing. And that's from somebody who was advocating for it. And I'll tell you, when we saw the ballot language, all of us as a group said, we couldn't have done this better if we did it ourselves. At that point, we thought we probably had a slam dunk. And I'm not trying to attack anybody personally, but that's just how we felt. And I guess maybe the last issue is none of us saw the ballot language, as far as I know. There may have been some group, but the groups I talked to, none of us saw the ballot language until it was done. It was a done deal. So there were at least 2 groups that I know of that did pursue court action to try to because they had objections to the ballot language. And as far as I know, what they had found out was that it was too late. There was nothing they could do about it. It was already on the ballot. Well, they weren't presented the language. So I guess what I'd like you to think about is coming up with a way to explicitly prohibit the expenditure of city funds or resources in any regard when it comes to the initiative or referendum, specifically when it comes to anything that would be educational or discussing it. And obviously that wouldn't prohibit city employees from doing that as private citizens, but just not using any city time for anything that could be construed as education. Looking at number 2 would be the ballot language. I'm still trying to review what state law requires, but making the ballot language as essentially succinct as possible. A vote yes is this, and a vote no is this. Period. End of issue. I think that might be all that's required, not necessarily this large text. Now, what the city clerk could do would be to come up with essentially, like we see at the state level, like sort of a ballot, a guide where my side could write what we thought, the pro side, and then there could be the con side, and then the con side can put their thing out too. And trying to be completely objective, I don't think the other side had a fair chance when I read that language. I think it helped us, but it didn't help them. Or it wasn't really fair to them. And then I think the last thing is a requirement that maybe the entire public, but at the very least ballot question committees, all get a chance to review the ballot language before it's solidified 10 days, or I'm not an attorney, I don't know exactly what that would be, but something in which there's a remedy so that they can, if they have a gripe with it, they can approach the city, and even if they want to take legal action, they can do so, just so everybody's due process is preserved. So I'm going to come up with more solid ideas hopefully in the next few months, but that's what I had so far. Thank you.
That will be on the agenda in the November meeting.
Okay, thank you.
Bruce Danielson, Sioux Falls. I'm glad Greg was able to bring up some of the things he was just talking about with the election, because in the last city election, I was involved in all 4 of the ballot measures, 3 of them from the losing side and 1 of them from the winning side. And I can tell you, as a person that actually brought about one of the court actions that almost postponed the city election, I have some real issues about the way that the election was actually conducted from the ballot standpoint. Because as we found in all 4 of the ballot issues that were citizen-driven, we found that each one of those had actually been rewritten by the city attorney's office in one way or another, so the original intent and sometimes the facts of each one of the issues were actually changed. And the city attorney's explanation of each one of those items, and I don't know if it was this city attorney that actually sat and wrote them or one of the other ones, but they actually did not match our original intent on any one of the issues. And that's really disturbing when we go out and we collect 27,000 signatures to put these items on the ballot, and then to go and get the actual ballot after it's been printed and find out that they did in fact include all these errors. And then we had no way in the end to dispute it because they'd already printed the ballots. We tried to get the ballot language fixed and we were rebuffed. And that's what caused us on April 7th of last year to actually take the city to circuit court to stop the election or the use of the ballot that was there. On the one in particular was the Spellerberg pool issue. And we can talk about technicalities of what a date means and so on, but yet when it really gets down to it, it's the sanctity of the ballot. And the sanctity of the ballot said the information that we put on, we circulated a petition. We promised the people who were involved in those petitions, signing those petitions, that this is what it's going to say on the ballot, and then to find out that the city attorney or an attorney can sit and rewrite everything before it's printed, and we have no way to go back and verify that that information is correct, that it means what we wanted it to mean, and so the election becomes kind of slanted in a way that's against what we were trying to do. And that's really disturbing for somebody who circulated his first petition in 1972. And I've circulated a lot of petitions through the years, and there's always been, when you read this information right here, that's what you're going to see on the ballot. And when we got the ballot, it wasn't what we had actually circulated. And that upset us. And there was no time frame in there that allowed us to have a chance to go in and correct it. So when we took that to court, we found out from the Secretary of State that the only thing that's required on the ballot is the bold-face header that's at the top. And everything else is just an explanation that says what a yes vote means and what a no vote means. All the rest of that is not necessary to be printed on the ballot. So we ended up using 17-inch pieces of paper to vote on, when actually we could have used the standard 14, and Lori and Bob Litz, in charge of the counting of the ballots, wouldn't have had so many issues with the crashing of the voting machines, because I was involved in that side of the election too and got to watch the machines crash, because the ballots were so long and they were so heavy that they crashed the old machines. So there's a lot of things that are involved with the election that I'm very particular to, and why I asked to be on the election review committee that the Minnehaha County had, and was the chairman of that to investigate why we were having some of these other issues. So I'm rather passionate about the area of balloting and elections and doing it proper. And that's one of my key things. And I'm glad we're going to split this up into different sections for each meeting, so I won't go through everything that I have here, but there's 6 things that I really want to talk about. One of them we've already done, but how the appointment to boards and commissions are done. And there's a process that I learned about in Omaha that I think is very fascinating, and it allows the city council to also have a chance to be involved in the process of selecting members and balancing the interests on an appointed board. And I'll get into that more at another time. One of the other things I've been studying is the direct election of the city attorney. So that way the city attorney's primary job is the protection of the charter, and it has nothing to do with the protection of any one particular individual who is in the city, in a city office, either appointed or elected. And that the city attorney shall not appear before any board or commission as a representative of an official. Last year, I went before the ethics board on 2 different occasions to discuss some issues, and in one of those, the city attorney actually took the position of one of the defendants on the ethics board, so we couldn't even question the individual that we called before the ethics board. We could not even have him in the room for those 2 times we called him before us so he could answer our issues that were involved. He had other people do his work for him, and that's absolutely wrong. If somebody goes before the ethics board, if their name is called up, I don't care what their time frame is, how long their day is or anything else, that person needs to be there to defend themselves. And that was an eye-opener to how the process worked. In the city council, there's a group of us that would like to see the chair of the city council lead all city council meetings. And we'll get into this in more detail, but the mayor is required to be in attendance in the city council, as it happens in a lot of cities. And the mayor may lead the administration discussions and issue presentations in front of the city council. The mayor is required to approach the podium in order to vote to break a tie. And we want to see that there's a balance in how the management of the city council works. And I'm glad we have a former member of the city council, so we can talk about some of these things and see how it all works. Greg did a great job. I wish we could have rehearsed it with the issues brought with the initiative and referendum. I won't go into it in detail because I think he did a fantastic job, but we do already have a problem with state law and the city charter being violated last year and how the advocational education sessions were conducted, and that's wrong. One of the things we learned recently in another situation was we seem to have this loophole, and state law and city charter both say that more stringent law or ordinance, when an issue arises, is what is supposed to be followed. Well, we had a special meeting at the regular time with the regular agenda because they didn't get the agenda posted. And I filed a complaint to get that meeting stopped because they should have had it at a special time. It could have even been an hour later. But at least that meeting, by state law, was actually illegal and by city ordinance. And if any one of those individuals that had that situation that night that lost or won, they could have fought it, and they probably would have won in court because state law is very clear on it. But we went ahead and had a meeting that we should have had at least 98 hours advance notice to, and we ended up having 24 hours notice to. That it was a special meeting called, and it was really strange. So that's one of the things that we would like to see if we could tighten up in the appropriate section. And then I personally have fallen into this situation, and so have a few other citizens in Sioux Falls, and that's the city of Sioux Falls shall follow legal service of code violations, and the city of Sioux Falls shall follow state law on all service of citations. Right now, we have code enforcement going out and just willy-nilly dropping pieces of paper in people's yards and saying that they've served some kind of a citation or ordinance, and then doing legal action against it, and it doesn't follow state law. Now, last year, I was in court on one of these situations, and one of the reasons we succeeded was because the judge determined that we did not get proper service. Talked to Dan Daly, I.L. Wiederman, they also have the same situations in their cases. And it happens, and through the year, as we've been watching the city work with code enforcement and people coming up to this very podium, they're talking about all of these times that they have not been given legal service. And we would like to have that addressed in the appropriate point. So thank you very much for your time. I would like to spend some time with each of you and work with you and try to explain what this is all about, and I appreciate your time.
Okay. And I think in the past, we've had a time frame as far as for public input.
Yeah.
We didn't have that tonight, but I think that's an item that we'll probably address in the future.
That's not a problem. This was a long one today, and I apologize. Thank you.
Thank you. Thank you for your input.
Come on, Soda Pop, let's go. Come on, let's go. Come on.